Pretrial in an Illinois divorce. After months of status dates, exchanging documents and waiting for progress, a judge may suddenly announce a pretrial and require a memo a week in advance. This usually means the case has not settled and the court wants to move it along. A pretrial conference is an integral part of every Illinois divorce. The process aims to resolve disputes without trial. Spouses must exchange financial documents and propose a parenting plan, and mediation is mandatory when children are involved. When these steps fail, the judge asks why. The court can recommend settlements or, if settlement seems unlikely, set orders to prepare for trial. State law treats the pretrial as a case management conference. Supreme Court rules require it to occur within about 6 months of filing, and the goal is to manage the case and avoid delay. At the conference, the judge and lawyers discuss the nature of the case, simplify the issues, consider amendments to the pleadings, and decide what evidence can be agreed on. They set limits on discovery, deadlines for witness disclosures and completion of discovery, explore settlement or mediation, and fix a tentative trial date. When children are involved, the court must decide whether to appoint a guardian ad litem or attorney for the child. Parents must attend parenting education, provide a parenting plan, and, if they do not agree, attend mediation. After mediation, the judge may hold another conference to set further deadlines. Orders entered after the conference record what was done and what remains to be resolved. They specify the issues that will be tried and include a timetable to ensure discovery finishes long before trial. These orders keep the case on track and require both sides to prepare. In Cook County, any party may request a settlement pretrial. Local rules require a written memorandum to be delivered to the judge and the other side 7 days before the conference. Judges prefer a narrative memo that tells the story of the marriage and explains why the court should rule a certain way. It should avoid lists and only attach necessary financial affidavits and previous orders. The memo should also state what discovery remains outstanding. Sanctions for failure to provide the memo are rare, and these conferences are generally informal. At the conference, each side summarizes its strongest points and responds to the other side's arguments. Litigants should be ready to tell the judge the terms on which they would settle because the judge often encourages both sides to move toward a middle ground. If settlement is impossible, they should ask for a trial date and clear discovery deadlines. Being prepared shows the judge that the case is important. The pretrial itself produces no binding orders unless the parties agree, but it is an opportunity to present your story. Because the judge hears each side's summary, asking for a different judge afterward is generally not allowed, so requesting the trial judge to conduct the pretrial waives the right to substitute. Sometimes both spouses agree that the judge's recommendations will be binding. A binding pretrial becomes a final order and cannot be appealed. These agreements are best for straightforward financial cases without disputed facts. In cases with contested facts such as child custody or alleged waste, a binding pretrial is usually a poor choice because there is no appeal. By statute, each party may substitute a judge once without cause, but that right is lost after the judge rules on a substantial issue. Courts now often require parties to waive substitution if they want a pretrial, underscoring the seriousness of the conference and how judges form early impressions. Pretrial conferences narrow disputes, encourage settlement, and prepare cases for trial. With a concise memorandum and good faith negotiation, a divorcing spouse can move the case toward resolution while protecting their rights. For guidance on preparing for a pretrial in your divorce case, contact the law office of Russell D. Knight at 773-334-6311, located at 1165 North Clark Street, number 700, Chicago, Illinois, 60610. This law firm offers personal counsel from a dedicated divorce lawyer. A skilled family law attorney can help you understand the pretrial process and advocate for you.